breakfast, dinner in the end. So let me start the second day with a panel on international law, natural law, and transnational justice. It's my great honor to welcome here, well, Jerne, he's my colleague, Jerne LegArg. Welcome back from the States.
Thanks.
Jerne is an assistant professor of human rights at the Graduate School of Government and European Studies, and where he also serves as a called the Vice Dean for Student Affairs, right? Jerne is going to talk about the long and winding road to human dignity. I was looking forward to hear what you're going to say about it. And then our next speaker will be Filippo Fontanelli. He's currently based at the University of Surrey, and you act as a lecturer
on WTO investment.
WTO and investment law. He's going to talk about the emergence of judicial tests as a new interstitial source of international law. Then, I would invite you to join the panelists, basically.
If you don't mind, I would like to see...
All right, okay.
If you don't
I don't mind at all. Yeah, I don't mind.
If you don't mind, I don't care.
Exactly. So the third speaker will be Raluca Frosescu. She's going to talk about natural law and positive law in transnational justice. As we discussed yesterday, you're a political scientist based at which university?
At Bucharest University.
Bucharest
Faculty of
University.
Political Science.
All right. And after the coffee break with snacks, this panel will finish off with Martin Lutheran, and he's going to talk about natural law and the postmodern principles of proportionality. And you are a rector of from close to Bratislava, right?
That's right.
All right, from Slovakia. So we have very much international panel. We have Italian, Slovenian, Slovakian, and Romanian colleagues with us. And I just opened the floor for your short presentations, 15 to 20 minutes, which will be then followed with some discussion. So Jerne, the floor is yours.
Thanks a lot. Good morning to everybody. Sorry that I couldn't be here yesterday. I was traveling back. My presentation today will address human dignity from the perspective of human rights law and traditional justice. In the first part, I'll just give you some principles on human dignity. What does it mean? Where does it derive from? Whether there is a consensus in international human rights law and also international justice about the definition of human dignity. Then in the second part, I'll try to connect this concept to the recent judgment by the Slovenian Constitutional Court in the case so-called Tito Street case. And then thirdly, I'll provide some criticism of this recent decision of the court and try to connect it with the definition of human dignity. What I'll try to make is the case for a really broad definition of human dignity, which is based on the principle of equality between human beings. But as you will see, the concept itself is very ambiguous and vague, and it's open to different interpretations. Now, as we talk about the notion of human dignity, the first time we can trace this notion is in the Roman law, the times of the Roman Empire, where the term hominis, dignitas hominis was constructed, and it was connected to the person's status in the society. One was not granted dignitas only because of being human, but because the person carried a position in society. And then later, Cicero developed a notion which is more naturalistic, which means that everybody, by the virtue of its birth, has a human dignity. Every human develops dignity by his birth. But in the context of philosophical and historical and religious definition of dignity, there are of course different interpretations of what dignity is. If we take a religious perspective, then the dignity is connected to the notion of supernatural, not connected with the existence of the God. Then if we take a philosophical point of view, the dignity would be connected to the different interpretations of from the philosophical point of view. And then if you take historical interpretation, this would mean what kind of human rights relations in the past would be interpreted as a violation of human dignity. And if we take these different interpretations of human dignity from historical, religious, and philosophical point of view, we don't get really the sense what human dignity is. The notion is quite ambiguous and vague. And if we move on from these definitions to the normative notion of what human dignity is, we are even more perplexed. Because the normative definition, it does not exist a normative definition of what human dignity is. If you look at a Universal Declaration of Human Rights, International Covenant of Civil and Political Rights, and different national constitutions, all of those documents refer that every individual has the right to human dignity, but then they don't explain what human dignity is, and therefore one has to look into legal, cultural, and philosophical traditions to fill this notion with the content. Now, if you just allow me to go through some propositions about the notion of human dignity by various writers, Christopher McCrudden, a professor from Oxford University, basically says that there exists a so-called core minimum element of human dignity. And that core minimum element of human dignity would mean that every individual, every human being possesses an intrinsic worth that should be respected. This is the first element, intrinsic worth that should be respected. And then the second element would be that some forms of conduct are inconsistent with respect of this intrinsic worth. So some forms of conduct would be in violation of this intrinsic worth. And the third element of his definition would be that the state exists for the individual, not vice versa. No? But then still we are left with wondering what is human dignity. And because also McCrudden doesn't really put forth what human dignity is. And now if we turn to the proposal put forward by Andrew McClellan, he's more concrete in trying to make a case for the content of human dignity. He would say that human dignity consists of four elements. And the first element would be connected with all types of inhuman treatment, humiliation, and degradation of one person by another. And then second element would be that human dignity is connected with all aspects of individual self-fulfillment. Then a third element would be that it's connected with the protection of a group identity of a person. And the fourth element would be that it creates necessary conditions for each individual's essential needs to be fulfilled. So here are some propositions what is the content of human dignity. Now we'll turn to the decision of the Slovenian Constitutional Court in it's a decision from September last year concerning Tito Street. Here the question was whether the ordinance put forward by the City Council of Ljubljana proposing the naming of the new avenue by the name of the former dictator Tito would be constitutional. And basically the case was brought by three petitioners who consider themselves the victims of the former communist regime in Slovenia. And here the Constitutional Court sees the opportunity to elaborate on the notion of human dignity, but you see, it didn't really provide what it means, what is the content of the human dignity. Of course, the plaintiffs were arguing in this case that new naming of Tito Street is unconstitutional, no? Because it affects the feelings of the victims of the former communist and totalitarian regime. And here the court said in paragraph 7 that human dignity is at the center of the constitutional order of the Republic of Slovenia, deriving from the basic constitutional charter and also the Article 1 of the Constitution of the Republic of Slovenia, which provides for the principle of democracy, democratic principle. Now, here in paragraph 8, we come to a more interesting part where the Constitutional Court basically connects this concept of human dignity to the naturalistic notion of human dignity, which says that every human being has equal and absolute inner worth because he or she is a human being. Here we can make connections with the definition put forward by McCrunan, where he talks about intrinsic value. Here the court talks about inherent worth of the individual against unjustified interference by the state and society. And here one has to acknowledge the development by the court, because it doesn't only says that the human dignity of person has to be protected against the state, but also against society, meaning non-state actors. No? That human dignity also applies not only in vertical but also in horizontal relationship. Moving forward, the Constitutional Court basically tried to apply this principle of human dignity to the context of the Slovenian society, and here it made a difference, or it says that a former communist regime was some kind of different regime of different quality to the quality of the Slovenian democratic society right now. And that's why the court said that there is an essential difference, and it's important that a distinction is made between the former totalitarian regime and democratic regime. Why is that? Because the former regime was based on the violation of human rights and disrespect for human dignity. What is more intriguing is that the court said that such naming also appears clear evidence symbolic significance and therefore demonstrates the manner of symbolic conduct of the public authority concerned. So naming of the titular street is of vast importance, no? Because it puts forward interpretation of history and society, which is very important with dealing with the past. And why is this so important? Why the court makes distinction between the former totalitarian regime and a new democratic regime which is based on rule of law and respect for human dignity? I mean, the reasons are quite obvious. Systematic human rights violations. Former regime was a police state which basically used a cult of the leader to abuse sentiments of the people. Also, basic human rights violations were connected with state terrorism, and power was abused in every aspect of daily life. Just to give you some examples, this is the map of Slovenia. What was one of the darkest chapters of Slovenian society, and one of the characteristics of the former regime are hidden mass graves discovered all over Slovenia. More than 640 were found so far, and still counting on the hidden places. The largest are in Tesno, in Maribor, and Huda Jama in Kočevski Rok in Slovenia. This is one characteristic and this is a photo of bones and skeletons found in the Barbarin road close to Laško in Slovenia, where almost 3,000 innocent civilians were massacred. So the court addressed this issue and found that the former regime was systematically violating human rights and basic freedoms of the Slovenian society. And therefore the court basically made quite a sweeping statement. If you look at the paragraph 18, it says that such a new naming of the street no longer has a place here and now, as it is contrary to the principle of respect for human dignity, which is of the very core of the constitutional order of the Republika Slovenia. Naming street after Tito does not entail preserving a name from the former system, and which today would only be a part of history. So naming of the street is contrary to the principle of human dignity, which is protected in the Article 1 of Slovenian Constitution. And on that basis, the court basically annulled the ordinance by the City Council of Ljubljana on the basis of this principle of human dignity. But here, two questions arise, which having to do with this judgment. One is the question of legal interest, the question who can bring a constitutional complaint or an action for annulment of the ordinance of the law before the Slovenian Constitutional Court. But this is also connected not only to the Slovenian, particular Slovenian national context, but also to the comparable national contexts in neighboring countries. And the second question is the question whether only the new namings of the streets after the former totalitarian dictators are contrary to the concept of human dignity. And here we come to back to the content of the human dignity. First, the question of legal interest. The court basically recognized the legal interest only to those free petitioners, and from those free petitioners only to one who individually suffered in the former communist regime. But one of the judges, Judge Zalbec, in his concurring opinion, basically wrote that such a legal interest should be interpreted widely. That not only direct victims of the totalitarian regime, but all of us who lived in the communist regime would have the right to bring an action before the Constitutional Court. And in his opinion, this is important due to the fact that once all the victims of the communist regime die off, pass away, then there would be nobody who would have an legal interest to bring a complaint before the Constitutional Court. So he argues in his concurring opinion that a legal interest should be constructed widely in the way of so-called actio popularis from the Roman law, so that everybody could bring a claim, just to protect the basic human rights and rule of law in the Slovenian society. But of course, I mean, his opinion was not very widely accepted by the rest of the judges, because here we have to know that the court adopted this decision by 9 votes to 0, consensusly, and you can imagine how difficult it was to arrive to the consensual decision by all the judges. Of course, it would be quite too difficult to accept that the court would also adopt a wide definition of the legal interest. But of course, I mean, if one argues for a wide definition of legal interest, that everybody who lived, or even who was born after the dissolution of former regime, would be able to bring an action, that would also apply not only to the victims of communist regime, but of course also to the victims of all other totalitarian regimes, namely Nazism and fascism. And then the second issue, which is even more controversial and pertinent, is the question: what did the court mean? Did it mean that only the new namings of the street after the former totalitarian dictators is contrary to the concept of human dignity, or already the existing names of the streets? Those who are last year in Gorica, Gorica is a street called Tito Street, and so it is in most of other Slovenian towns. Some Slovenian towns even nowadays carry the name of former leaders of the communist Communist Party. So, for example, Kidričevo is a town which is the name. And here I would argue if we apply a broad definition of human dignity which is based on a notion of equality, this decision should apply also to the previous namings of the streets, which continue from the communist regime to nowadays. If the court says that a democratic system is totally different from the previous communist regime, why it doesn't then make a statement that also the old namings are contrary to the human dignity? And why is that? Because I mean it's quite highly problematic. Most of the symbols from the Nazi and fascist regime in Slovenia have been removed. You have to know that Slovenia is the only EU member state which had in the last century was subject to all three totalitarian regimes, Nazism, fascism, and communism. And most of the symbols from those two totalitarian regimes were removed. But as I said, there are still symbols from the communist regime. And if you will get a chance to go on a tour of Ljubljana, tour around the Square of Republics in Ljubljana, you can see that that square is surrounded by symbols from the former communist regime. And we can hardly find a symbol from independent Slovenia. And here's the statue of the partisans, if I'm correct, no? Well,
I think it's Cardel.
It's Cardel, okay. Edward Cardel.
In between the folks, people.
Right, in between the regular persons. No? This is just right next to the Slovenian Parliament. And this is my favorite, it's Boris Kidrič. It's really a huge statue just behind the Slovenian cultural home,
It's called the Square of Council of Europe.
Okay, Square of Council of Europe. And usually when you pass by...
Just explain for the rest who is the guy, who is Kidrič?
Boris Kidrič, he was one of the former communist leaders after the Second War. The guys who supposedly, allegedly decided about these mass killings after the Second War.
I think he was the first president of the first communist government.
Okay, president of the first communist government. And usually when you pass by, there are flowers on candle, which is like a and those are two symbols, no? And here we have €2 coin, which is still used in Slovenia, having the sculpture of
For now.
Commandant Standard Osman. Still a very highly controversial figure. And there is still a man who is alive, who was given a medal of honor by the Slovenian president. He was the last former head of the secret police in Slovenia. And of course, the former president of Yugoslavia, Tito, no, for some former president, for others, dictator, no, is still widely used in the Slovenian culture, in nostalgia. This is one of the actors who is impersonating him, Ivo Gonic, if I'm not mistaken. You know? So there are still a lot of like symbols in everyday life, in the names of the streets, monuments, and so on, which carry the names of the former figures from the former regimes. And we want to ask ourselves why the Constitutional Court didn't go a bit further and apply the notion of human dignity based on the right to equality to all the symbols which are still persistent of Slovenian society. You know? And here I can mention just briefly the resolution of 1481 by the Council of Europe, which says that member states of Council of Europe have to address all the actions of the former totalitarian regimes equally. No, they shouldn't make any difference. No? Okay. Just to conclude, in my talk I tried to argue that human dignity derives from the basic notion of equality, and that it should be construed broadly, and that it has basically four continents. One is based on the rights which are connected to the security of person, human dignity, and human treatment. This was also confirmed this year by decision of the European Court of Human Rights in the case of Yanovich and others versus Russia, where the court said that silence of the authorities to address these questions is to be considered as an inhuman treatment or degrading treatment in the notion of Article 3 of the European Convention of Human Rights. Then the second element, human dignity, is that it's connected to individual self-fulfillment. Third element that groups should be also protected in the notion of human dignity. And the fourth element that human dignity has to be interpreted in the way that it satisfies the basic needs of individual. But as you have seen, the human dignity is very ambiguous and value connected notion, and is more or less connected to also to the ideological divisions in particular society. That's why we don't have a really sweeping definition of human dignity, nor in the Slovenian society, nor at the international level. But of course, it would be necessary for the courts to adopt a wider definition of human dignity, maybe in the decades to come, where the society will be more mature as it is right now. Good. Thank you.
Thank you, Renee, for this interesting presentation, and now I'm opening the floor for your questions. Great.
Okay, so I would have two questions. The first one, if there were legislative proposals in Slovenia in order to remove communist symbols.
Sorry.
If there were legislative proposals in Slovenia with regard to the removal of communist symbols. And the second is, what transitional justice measures were adopted in Slovenia with regard to the communist regime, if there were any?
Please.
Should we take more, or?
No, we take one, but I mean, at least we were used to take one.
I mean, there were attempts to adopt a statute or revisions of the statute to address this issue, but this is highly controversial issue in Slovenia, and there is no consensus in the society. I mean, there is not even consensus to open these mass grave sites, you know, for the public, that the children and the students would teach and study this issue that happened. There is no consensus that these issues should be placed in the school textbooks, historical textbooks about that. So the answer would be there were attempts, but they were doomed to fail, because one part of society would say that this is nothing to do with human rights. This was just a justified retaliation after the Second World War, and those persons were not criminals, were not dictators. They were just a very respectful statesmen. And as regards transitional justice measures, Slovenian Parliament adopted a couple of years ago a resolution condemning all the totalitarian regimes, and also Slovenian government, and a couple of statutes were adopted, so-called war victim statute, and a couple of others, but those statutes basically still impose a discriminatory principle, because for example, this war victim statute, it gives a right for compensation only to the relatives of the victims which fell on the side of partisans in the Second World War, but not on the side which fought partisans in the Second World War during the so-called civil war in Slovenia. So the legislation which is in place right now is quite discriminatory. Yeah, I would say also unconstitutional. And therefore the transitional justice measures are very, I would say they are very piecemeal, and not adequate at all.
Okay, really good.
Just a quick parallel that came to my mind when you said that actually there is a problem in conceptualizing this judgment, because then you don't know exactly what to do with all the titular street around. And if the rationale is that there is this big divide between what is now and what was before, they should go as well. I don't know if that is the reason. I don't know actually if that is the reason in the other case I'm thinking about, which